I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're exploring a proposed constitutional amendment in New York that would redefine the state's obligation to respond to the needs of New Yorkers struggling with mental health problems. For more on this update to language that stems from the 1938 Constitutional Convention in New York, everyone's favorite, we're joined in the studio by James Norton, Government and Community Affairs Manager for the New York affiliate of the National Alliance on Mental Illness. So, James, under the state's existing constitutional language, what obligation, if any, does the state have to address the mental health needs of New Yorkers?
So one of the things that this bill looks to address is the wording of may and shall. Right now, New York State has the may, or the ability to do things to address mental health of its citizens. And we're hoping to change that to a shall. New York State has an obligation to address the mental health of its citizens. There is quite a bit that New York State already does. There's already an Office of Mental Health, there's already an Office of Persons with Disabilities, there's already an Office for New York State OASIS that handles substance use disorders, but that has continued to be a may. And so we're hoping to make that a more affirmative firm. The state is doing things to tackle mental health.
And from a practical perspective, though, what does that definition mean? Because may clearly gives you the authority to take something on. Shall could imply that, yep, you have to do this, but what does that look like? Because someone might say, hey, I've got a mental health condition and maybe it took me 3 weeks to get into care. I think this should be 1 week given this shall. I mean, what do you see this meaning in terms of the rubber meeting the road?
In terms of rubber meeting the road, I think it protects a lot of what we already have in place or the progress we have made. COVID has done a significant amount to change public perception around mental health and the stigma around it. And Governor Hochul, to her credit, has done a lot for mental health. We're really hoping to see that solidified with the passage of a bill like this. I don't foresee a large amount of, say, lawsuits that would go to the state because they're not doing things to do mental health in ways that people like, right? There's not a lawsuit for the banning of trans fats and that for public health purposes. I don't foresee too many people taking the case for you'd need to do more to address mental health in ways that are specific to their individual case. I've talked to a number of organizations that do advocacy and legal work for individuals with mental health and disabilities. Their overarching goal isn't to be able to take New York State to court over constitutional issues. Their goal is to see their clients get the help they need. We see this as a way to kind of solidify the work that the state has done to support mental health in a way that is constitutionally obligated, not in the optional.
Well, I think about my experience with the state's freedom of information law. And right now, if an agency continuously says, yep, we're going to get there, but we got to do an extension, we need an extension, we can file an appeal saying that this was an effective denial. Even though you say you're still working on this, it's just as if you had said no. And I wonder whether the same thing could be at play here. Take an issue like ensuring that the Medicaid population, those low-income kids who are looking for mental health services in their community, are getting those in a timely fashion. That is something that was actually the subject of a lawsuit, and now the state is doing a fact-finding time period to figure out how to implement that, and then they've got even more time to implement that. So under this language, could you envision someone saying, hey, it's great that you say you're doing this and you shall get to it at some point, I guess, but the timeliness of it matters. I mean, is that a potential sticking point here?
So I'd say with that youth case specifically, it had to do with an agreement that New York State had made with the Center for Medicaid Services in their expansion, as well as Americans with Disabilities Act. They did not provide enough community-based and home-based services and essentially forcing youth into programs where they went inpatient, even though that might not be the level of care that was necessary. It could lead to more investment from the state into resources that support people in communities, as well as more resources for the mental health workforce. I often highlight the TII issue because that's
cost of living adjustment for the workforce.
For the last 3 years, we've gotten a cost of living increase, but for the 20 years before that, we didn't. And so what we're hoping to see out of this is more of a system where the state continues to make those investments into the mental health system in ways that make sure people's mental health are addressed, and not necessarily in ways that would be limited or cause all of these lawsuits, but in ways that maintain the current system and maintain the progress we have made in mental health.
But why doesn't the timeliness factor into this equation? Because let's say I am one of those kids, and because the state has a long time horizon for actually implementing the changes that you just talked about, I'm never going to realize that benefit. You have effectively denied me this pathway. So wouldn't this language essentially give me a pathway to prompt a faster response from the state in this and other situations?
Yes.
Okay.
It would. Again, I don't want to paint this as an opportunity to sue the state of New York, but it is an opportunity to guarantee mental health care for those who need it.
And the fiscal implications, according to the bill memorandum, they are undetermined. But right now, if we were to provide meaningful mental health services to everyone who has some sort of disorder or defect, and that's the language in the Constitution, what could that potentially cost? I mean, I have to imagine we're thinking billions of dollars here?
Yes, over the long term, it would be billions of dollars. We already do put in billions of dollars to support mental health services. For years, we've talked about this idea of mental health parity, treating mental health as part of the health system and not isolating or excluding or diminishing the value of mental health in terms of supporting people's care. Yes, we hope that a bill like this would have an impact where there is more investment into mental health. The costs are undetermined. The language doesn't designate you have to put in X amount of money or X percentage of your budget. It says that the state has an obligation to spend money to support mental health services. And it, much like public health, right, we do a significant amount of investment into the Department of Health or other public health services. We want to see that similar investment into mental health.
And sometimes when we have constitutional amendments, there is an accompanying enacting legislation, something that's supposed to help guide lawmakers and agencies on what the implementation of that constitutional amendment might look like. I'm not aware of that happening in this case. So are you concerned at all about the possibility that by just making this one small tweak, that the implementation of it might not go as you envision?
You know, implementation with fidelity is always a question whenever you are passing any legislation. If you're looking for bills that would outline how to improve the mental health system, I've got a multi-page priorities list. And I don't think anybody in the legislature is not aware of the mental health crisis we're currently looking at or the opioid crisis we've been facing for a number of years. I do think that we have a bit of a roadmap for how to respond to the mental health crisis and substance use issues. I think it's a matter of identifying the best ways to do that and putting the urgency out there to try to address this mental health crisis before more people are harmed or hurt or lose their lives.
You said earlier that you don't necessarily envision this being the impetus for lawsuits from individuals or groups based on their experience with the state. But do you think of this then as a tool to challenge maybe future rules and regulations or maybe even funding decisions based on the idea that it deviates from the track record that has been established recently, and maybe that's sort of the new baseline of care and support that is expected from the state?
Honestly, the way we envision is what you're outlining.
Okay.
Right? There would be a relative interpretation to what it means to address mental health, similar to the improvements we have made the last 10 years or so. We also would hope to see cases where it systemically improves the mental health system. Again, highlighting the more urgency towards more mental health parity or to more services, to supporting the behavioral health workforce, to supporting the families that were in that initial case. There are good arguments to say that, we should be investing more here,
Sure.
or we should be doing more to address, say, a more active enforcement of mental health parity so that people don't get denials or delays for care for mental health, and that hopefully puts that impetus on the state to do those things. In saying that, I don't anticipate a large number of lawsuits. There will likely be some.
It is New York, after all.
It is New York. But I don't foresee a scenario where all of these mental health agencies that are already working diligently to address the mental health system suddenly become part of large class action lawsuits and take the state to task over all of its mental health investment, because it has been investing in it. I do see this as a way to have the legislators who are in office right now solidify all of the great work that they've done the past few years, while also acknowledging that there are areas where we can improve.
The governor in particular, and policymakers more broadly, don't typically like to have their hands tied in terms of what their options might be on a policy moving forward. And the wonderful part of that may language that we mentioned at the top is that, you have the authority to do this. You also have the authority to ignore it, whereas shall really directs them on a path that limits their options. And I'm curious, as you lobby for this bill, which is not a new one in Planet Albany, it's passed the Assembly before, hasn't, I believe, made it through the Senate, let alone the repeat passage that you need with a constitutional amendment like this. What sort of concerns are you hearing from lawmakers about well, we don't want to be hamstrung like this. We don't want to have to be tied to fulfilling this constitutional obligation. Sure, we'd love to in a perfect world, but we don't want to let the perfect world that we don't actually live in tie our hands.
No, I have not gotten that feedback from a legislator yet. If I were to get that question, I would say that they have a very similar obligation to address public health.
Sure.
They have a very similar obligation to address public safety. I don't think we're introducing a novel concept that they have to do things to address mental health. It is more about solidifying it, again, going into the future. Mm-hmm. And I think there's a lot of legislators who are interested in this bill and hope to advance it, not just because they want to tie the hands of themselves or their future legislators, but because they feel that the state has a more moral obligation to address the mental health of its citizens, just like it does for its public health, just like it does for its public safety, and anything else. This is not the first area of concern that New York State is obligated to address.
Well, we've been speaking with James Norton. He's a Government and Community Affairs Manager for the New York affiliate of the National Alliance on Mental Illness. James, thanks for visiting us in the studio.
Terrific. Thank you, sir.
Fraud and lawsuit abuse raise car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact, but some Albany leaders want to keep the status quo. Information on these reforms is available at keepnewyorkaffordable.org.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.